Hey guys, we have ourselves an incredibly angry little gremlin Karen over here today. And she gives this judge a bloody well run for his money, but he's having absolutely none of it. Check this one out. If you like it, make sure and hit that like button and let me know what you think.
Are you Miss Blasma?
Bilesma?
Is it Sarah?
Bilesma?
All right, what are we doing today, gentlemen?
So for the record, this case number 24S18976F8, people be Sarah Bilesma. Bilesma is present via Zoom from the jail, or Mr. Franklin is present in court today, the daytime for a status conference. I have had the opportunity to talk with Mr. Franklin a bit more about the case. I have adjusted the offer a bit. The offer is for the defendant to plead guilty or no contest to counts 1 and 3. We'll dismiss count 2 for an habitual. We would kill it with a jail gap. That's the change. That offer is open for today. The PSI, probation, fines, costs, restitution. We would include count 4 of the MDOP. In this case, no contact orders would remain.
All right, and Ms. Franklin, what's your client's wishes today?
Ms. Bilesma, you just heard the offer. It does include the jail cap, something that you and I have talked about a lot. Today is the first day the prosecution has offered that. If you want to take that today, you can. If you'd like to talk to me in a breakout room, I think we could probably arrange that as well, but it's up to you.
What's the cap? What's the jail cap?
It's just a jail cap. So it'd be.
Well, I need a day. How many days? What's the jail cap on that?
It would be no more than 12 months, plus the credit you already have.
To plead guilty when there's, okay, I just was hoping that the judge could clarify if there's evidence even against me. Because there's no injury, so I'm wondering how I'm being held
Would
against
you
for
like-
a four
Sarah, you
year
want to talk breakout room real quick?
with no
I
evidence.
want to just put you in a breakout room and then she
Well,
doesn't say something.
no, he doesn't help me. He doesn't help me. I'll just plead guilty. No contest. Because I'm not gonna win anyways, but there's no evidence even against me. There's no injury. There's no injury. How am I even in jail?
Miss Blasma, then I'm going to place you in a breakout room. You can talk to your attorney about it.
Lawyer's not helping me, sir. I need you as a judge to know.
I'm not your advocate. All right, I can't advocate for you.
There's no evidence. How can you as a judge charge me when there's no evidence of injury?
So deputy, can you
charge me, judge?
Ma'am, if you'd stop, I'm going to have you talk to your attorney. Doesn't need
I
to
don't
have
wanna talk
any
to
injuries for these charges. None.
I don't want to.
Is there a
There's no
place that
injury.
she can be placed that she can talk to Mr. Franklin while we still have the jail camera there available to continue our docket?
Now, don't worry, I saw the guy with the fez too, with the word Bay at the end of it. And trust me, that is going to be coming up just after this video, and I will have it linked also for you down below, and maybe in a playlist or something like that. You'll find it. You'll find it. It'll be the guy with the big red fez. Can't miss it.
It's my understanding that she's willing to enter a no contest plea.
All right, is that accurate, Ms. Bilesma?
Yep.
All right, and then I heard earlier that's going to be counts 1 and 3.
That will be counts 1 and 3, Your Honor. Yes, I do have amended information here as well as license rights. We'll have this part.
All right, Ms. Bilesma, if you raise your right hand, I'm going to have you sworn. You solemnly swear from the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yeah, just don't ask me if I did it.
I didn't catch that. That's just a yes or no question.
Yeah.
Okay, you can put your hand down. Ms. Bilesma, the charge in count 1 is assault with a dangerous weapon. That's commonly known as felonious assault. That's a 4-year felony and or a $2,000 fine. DNA is to be taken upon your arrest, and a consecutive sentence could be imposed if the assault was committed in a place of confinement. Now, count 3 is resisting or obstructing, thank you, a police officer. That's a 2-year felony and or a $2,000 fine. A consecutive sentence can be imposed if the assault was committed in a place of confinement or for another violation arising from the same transaction. Ms. Bilesma, do you understand the nature of those 2 charges and the maximum penalties associated with those 2 charges?
I thought we were capping and I wasn't gonna have to do consecutive.
I'm just informing you of the maximum charges. The agreement that you have with the people has already been placed on the record, okay?
Oh, it's not gonna be no like 12 months and 12 months consecutive, because I feel like I'm being tricked here anyhow.
Okay, so I didn't hear anything about a consecutive sentence as part of your agreement. Is that accurate, Mr. Butler?
They'll be concurrent.
Okay, so they said that they'll be concurrent if that was placed on the record.
Well, sure, then I'm guilty as charged.
Okay, so let's have you listen carefully to the court's question. Do you understand the nature of those two charges? Let's start with that.
Yeah.
And do you understand the maximum penalty with each? Okay, they can be up to 4 years and up to 2 years, and both of them could be run consecutive if that wasn't part of your deal. Okay, so do you understand the maximum penalties?
But that is part of my deal, right? I'm not getting any more than 12 months, right?
That's what the prosecutor just said. So if you listen carefully, you're answering your own questions.
Yeah.
Do you understand the maximum penalties?
Yes.
Okay. Ms. Bosman, do you understand that if you go forward with a plea, you won't have a trial of any kind? Is that what you want to do? Is waive your right to have a trial so you can take advantage of this agreement that's been placed on the record this morning?
Yes, I'm probably coming back for prison when I violate probation now.
All right, well, we can cross that bridge when we get to it, but that's not the best attitude to have going into supervision at some point, but we'll get there later. All right. So you don't want to have a trial. Is that what I'm hearing?
I'm not going to trial. There's no point. Yeah.
All right. When you waive your right to have a trial, you waive all of these rights that I'm going to explain to you now. All right. So just listen, and then I'm going to ask you a question about it. Okay. So you're waiving the right at trial to be presumed innocent, not just of counts 1 and 3, but all the charges you're facing. You're waiving the right to confront any witnesses that might be called against you or to call your own witnesses. You're also waiving the right to testify at a trial or not to say anything, and then the trier of fact couldn't use that against you. You're also waiving the right to have the assistance of an attorney at a trial. You could have Mr. Franklin throughout a trial and even post-trial if you wanted to go that route. Ms. Boswell, are you waiving all the rights that would come along with a trial, again, to take advantage of the agreement that was placed on the record this morning?
So, if I plead no contest, am I able to take this to an appellate court to get it out of Ironton County?
Well, we're going to talk about that in 1 second.
Okay.
So are you waiving all the rights that would come along with a trial?
Yeah.
Okay. 2 more things you waive by waiving your right to have a trial. The first one is this: you waive the right to claim at a later date and time, sometime in the future, in other words. You're waiving the right to claim it wasn't your choice to enter these pleas this morning. In other words, you can't come back later and say, hey, wait, on February 20th, it wasn't my choice to enter no contest pleas. It was Mr. Franklin's, or it was my boyfriend Bubba, or whoever it might be. You can't come back later and say it wasn't my choice. Do you understand that?
100% my choice. I'm willing to try to get this resolved as quickly as possible.
All right. So you understand that you can't come back later and say it wasn't your choice this morning?
It's my choice to plead no contest, yes.
All right. Here's the other thing that you waive. You waive the right to come back later, in the future, in other words, and say that there were other promises or threats or inducements to you except those we've already placed on the record this morning. Do you understand that?
Yes.
Okay. Now here's what you asked about earlier. Even with these pleas, you're going to have a form of appellate review available to you. It's called leave to appeal. And with that, you could hire an attorney to file that for you. If you couldn't afford one, you could request an attorney from the court. Do you understand that?
Oh, absolutely. That's what I will be looking forward to doing. Thank you.
All right. So just because you seem anxious to do that, I'm going to then go a little further than what I'm even required to do. Do you recognize that leave to appeal means that the Court of Appeals, because you're entering a plea, doesn't have to look at it at all? They can summarily say no. You understand that?
I probably won't even file any paperwork anyways. I'm kind of like giving up anyhow at this point. For any justice.
Okay, well, here's the difference. If you go to trial and you lose, then the Court of Appeals has to review your request. If you enter a plea, you can file an appeal and they can summarily say no without any review at all. So that's the difference. Does that change anything for you?
I know, yes. I'm gonna be sitting in here for a year just to go to trial.
Well, you're not gonna be there for a year to go to trial. If you want a jury trial, we'll get it on for the next jury selection date. That's every 3 months or something like that. So you'll have trial dates a week or so after that.
Another 3 months, sir.
But I don't know when my next date is. You wouldn't be on my next date, so it would be out for our next term. So I don't know when that would be off the top of my head, but it would be probably 2-3 months at least.
Yeah, 6 months, I got 12 months done here, so I'll just plead no contest.
All right, so I'm gonna go back to that question. Do you understand your right to appeal is gonna be limited because of a plea? Do you understand that?
Yeah.
All right. Now, Ms. Boswood, let's talk about those charges, okay? Now, count 1 is assault with a dangerous weapon, commonly known as felonious assault. How do you plead to that charge?
No contest.
All right, and count 3 is resisting, obstructing a police officer. How do you plead to that charge?
No contest.
And then Mr. Franklin, the reason for these no contest pleas?
Your Honor, lack of independent recollection.
All right, the court does find that as a factual or an appropriate use of the no contest plea. And Mr. Butler, you don't have any objection to the no contest pleas?
No objection.
All right. So then I have before me what's been marked as People's 1. It is incident number 5671-23. It's a police report authored by the state police, 9 pages in length. And then there is I guess it's just 9 pages in length. Mr. Franklin, do you have any objection to the court receiving 1?
No objection.
Court will receive 1. Just give me a minute to review it. I do find factual basis for 1 and 3. Also do find it confirms venue as related in the information Alliance Township, County of Ionia, and our date and time of on or about October 13th of 2013. Mr. Butler, anything else on the facts?
No.
Mr. Franklin, how about you?
No, Your Honor.
All right, Ms. Boswell, I'm back to you. Other than what we have talked about here this morning on the record, has anyone else promised you, threatened you, or done anything to you to get you to enter this plea?
No, sir.
Okay, other than what we have placed on the record this morning, has anyone else said anything to you about what your sentence will be as a result of entering these pleas? And I'm not talking about Mr. Franklin, that's his job. I'm talking about, has anyone else said anything to you, like your aunt or your bunkie in the jail there or somebody else? Has anyone else said anything to you about what to expect for a plea or a sentence?
Nobody cares, sir. The only 2 people that care are my kids. They don't
All right,
know.
but they haven't said anything about what your sentence might be?
They wouldn't know.
Okay. Mr. Butler, are you aware of any other promises, threats, or inducements to Mr. Bowser?
I'm not.
Mr. Franklin, how about you?
I'm not.
Mr. Butler, you believe the court's complied with the court rule for taking the no contest plea? Mr. Franklin?
The court has.
Okay. Ms. Bosman, do you have any questions about anything that we've covered now that we're just about done with this process?
Nope.
All right. Last question. Do you want the court to accept your no contest pleas to 1 and 3?
Yep. Yes.
I'm sorry, I didn't catch that.
Yes, sir.
Okay, I will accept your pleas. You did offer them freely, accurately, and voluntarily. So what will happen next, ma'am, is somebody from probation will be contacting you to begin the process of completing this pre-sentence report. Once that's completed, Mr. Franklin's going to get a copy of it, and he's going to go over it with you the day or 1 or 2 days, maybe the morning of, before sentencing. And that's so that the 2 of you can review it and check it for accuracy. All of that will occur, and then sentencing is generally going to be about 4 weeks out. All right? So I'll see you in about 4 weeks. Okay, if there's nothing else, that'll conclude the matter.
Thank you.
Well, it seemed to me like that little Karen decided to calm down a small bit, probably after her lawyer had a word with her. I mean, where do these people think they get off for 1 minute suggesting that a judge is gonna just give them everything they want because they raised their feckin' voice a bit? Anyway, lads and lassies, I hope you enjoyed it. If you did, smash that like button and we'll catch you in the next one. It's Launcha.